Hello, everyone, and welcome to the sixth and final webinar in our 2024-2025 series. My name is Mike McMahon, and I'm Executive Director of the Hymn Society, and it's my pleasure today to introduce my colleague, Brian Hehn, who is the Director of the Center for Congregational Song. He also serves as Director of Liturgical Worship at St. John's Lutheran Church Sweet Air in Phoenix, Maryland. He's a graduate of Wingate University and Perkins School of Theology at Southern Methodist University. He's a published author and a composer in the field of church music. And as director of the center, Brian has spearheaded many efforts that have expanded our reach and that have sparked conversations on a variety of topics. One of those subjects about which he's been fostering dialogue is copyright. And so he's identified a whole host of questions and listened to a variety of perspectives. I'm looking forward to hearing what he has to say to us today. So, Brian, take it away.
Thanks, Mike. Hey, everybody. See some names I know in the participants list, and I see some names I don't know. So if I know you, hello, it's great to see you. And if I don't know you, hey, it's great to meet you. I thought I would start off, I'm going to throw into the chat. I've got a handout for this. It'll remain available after the webinar, and we'll include it in the video description in YouTube. But if you want to download the handout, it is there. It's a PDF, or you can just view it on your browser if you like. The second thing I'll say is that this presentation is, like Mike said, I've learned a lot about copyright from being a part of various conversations and learning from various industry professionals. And in particular, over the last 2 years, I did a series of listening and learning sessions about copyright with intellectual property lawyers and publishers and things like that. So as I curated those conversations, I got to learn a lot. But I am not an intellectual property lawyer. And these are also, anything I say is not the official stance of the Hymn Society, even though I work for the Hymn Society. This is Brian presenting, all right, as an invited guest on the webinar series, just like any other guest. So I want to make that clear up front. So now let me share my screen and we'll get going. So you are here, theoretically, to learn about congregational song and copyright. I thought we would start by, I want to read you a text that I wrote as I was thinking about this presentation. Amazing grace, how sweet the sound that saved a wretch like me. I once was lost, but now I'm found, was blind, but now I see. So it's always good to learn new hymns. And so that's one I wrote. You're welcome to use it anywhere you like. And we'll come back to that later. So thought we'd back up and do a brief history of copyright in the US. Now, if you're here because you want practical advice on what to do about copyright, we will get to that. But I first want to make sure that we all have a firm grasp of how we got to where we are. So I'm going to go over the history of copyright in the US. I'm going to go over kind of the current law as I understand it. And then I'll go into the kind of practical applications of what does that mean for us as pastors and church musicians and church secretaries and things like that. Speaking of church secretaries, actually, let me unshare my screen so I can show you this. It's very exciting. Last week in staff, or 2 weeks ago in staff meeting, they were cleaning out the office and they found a pile of Church Secretary Today newsletters. And in 2004, the lead article was copyright law and the church office. So, you know, it affects us all. Even the church secretary's newsletter in 2004 was concerned about it. So I know that this is a big concern. So thanks for being here. All right, let me reshare my screen here. Whoop. All right, so in the late 1400s, the printing press was introduced to England. The reason this is important is because prior to the printing press, copyright wasn't really a big concern. But once the technology arrived to help us to mass produce artistic creations like books and uh, pictures and things like that. All of a sudden, it became a thing. And so in 1710, the statute of Anne in England wrote, established the principles of authors' ownership of copyright and a fixed term of protection of copyrighted works. And that included 14 years and renewable for 14 more years if the author was alive upon expiration. So the initial terms in England, which U.S. law is very much based on, was 14 years with a renewable 14 if they're still alive. In 1787, the U.S. Constitution, Article 1, Section 8, Clause 8, this is the original Constitution, not some sort of amendment, states that the Congress shall have the power, lots of things, to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. In 1790, so just a few years later, Congress passed a law called the Copyright Act of 1790, which granted American authors the right to print, reprint, or publish their work for a period of 14 years and to renew for another 14. Sound familiar? Thanks, England. The law was meant to provide an incentive to authors, artists, and scientists to create original works by providing the creators with a monopoly. At the same time, the monopoly was limited in order to stimulate creativity and the advancement of science and the useful arts through wide public access to works in the, quote, public domain. So this idea of public domain and copyright within the US goes all the way back to the beginnings of the country. And in 1831, it was amended, that law that ended to, or the original term to be 28 years with a 14-year extension. So it was increased by 14 years. Now, when we start approaching 1900, we get the 1886 Berne Convention, which was adopted by almost all the European nations to create uniform copyright law across sovereign nations. And we became a signatory in that in 1988. So it took us 100 years, but we got on board. But this happened in 1886 because they realized that if the countries with lots of creative overlap and interweaving of crossing borders and sharing ideas and stuff, if the copyright laws weren't uniformed, it created a lot of problems. And in 1908, they revised the Berne Convention and set the copyright at the life of the author plus 50 years. So within about 100 years, we went from a 14-year with a 14-year renewal, so 28 years total possible, to the life of the author plus 50 years. So if someone made something when they were 20 years old and lived until they're 70, that's 50 years plus another 50 years. Their work could be copyrighted for potentially 100 years. So in 1909, remember we hadn't signed on to the Berne Convention yet, our Copyright Act gave 28 years and then increased the renewal to 28 years. So now we have, 56 years possible. And they wrote, the Congress wrote, the main object to be desired in expanding copyright protection according to music has been to give the composer an adequate return for the value of his composition. And it has been a serious and difficult task to combine the protection of the composer with the protection of the public, and to so frame an act that it would accomplish the double purpose of securing to the composer an adequate return for all use made of his composition, and at the same time prevent the formation of oppressive monopolies, which might be founded upon the very rights granted to the composer for the purpose of protecting his interests. So they're trying to hold in tension this idea of honoring artistic creation and the people who do those things to make sure they get compensated so that we can have professional artists and we can incentivize monetarily, artists of various kinds, but also, if things are held too tightly, then the good of the public to be able to improvise off of and use those creative things to then continue more creative things gets hampered. So how do you balance those two things? That's what they're doing. In 1976, the U.S. Copyright Act revision created copyright. Yeah, his Honor Hernandez says his is his. Well, I can't do anything about the ingrained patriarchy in 1900, but we can do something about it today. So let's do better. 1976 U.S. Copyright Act revision created copyright as life of the author plus 50 years. So the US was preparing to sign on to the Berne Convention, which meant that our laws had to match or exceed that minimum Berne Convention standard of life of the author plus 50 years. And so they did that. They also created this fair use clause was created to determine whether the use of a work is a fair use. The following 4 factors are to be considered: purpose and character of the use, nature of the copyrighted work, the amount and substantiality of the portions used in relation to the whole, and the effect of the use on the potential market. Now, this fair use clause comes up a lot when people are talking about copyright, especially music and all sorts of things like that. And so we'll talk about that later. But it is in the 1976 Copyright Act revision. So that is in the law, in the books, and that's how it reads. Then in 1998, the Copyright Term Extension Act creates the life of the author plus 70 years. So instead of 50 years extension, it's a 70 years. And then, interestingly, a case was litigated, and there are not very many copyright cases that were actually litigated. Now, if you're familiar with how this works, if you're not, let me just back up for a second. As I understand it, the way this works is the Constitution is created. It's very vague about a lot of things. Congress makes laws, right? And the laws sometimes can be can go against what the Constitution meant, right? And so, but they're also helpful because they specify what the Constitution might have meant, but didn't actually say. So we get these laws. Now, the way we determine if the laws are constitutional, or if the laws are still pretty vague, what does the law actually mean? That goes to the courts, right? And so in order for us to really know what a vague part of the law means, it has to be litigated in court. Because if it's not litigated in court, we never get the final judgment from the court systems to say this is what the law actually means, or this is how it actually applies. And so for unlitigated laws, it's subject to interpretation unless the law is very, very specific. And in this case, it's not. And so there's a lot of vague parts of this that have not been litigated. But in 2003, Dastar, I don't know how to pronounce that, corporation, and 20th Century Fox Film went at it and actually litigated a copyright case. And what they did, I can't remember which one. One of them took some public domain works. They repackaged all of these. It was film. It was some really old film. They repackaged all these works and sold those works for a profit. And they didn't, say that the original, was owned by 20th Century Fox or whatever, whatever. They didn't credit anything. They just said, here's this package of old films and we put it together. And the court said they can do that. They did not break the law. You can take public domain works, which right now means anything, for sure, anything written in 1929 and before. You can do anything you want with it, and it does not break the law. Which is why, at the beginning of this presentation, I could claim to have written Amazing Grace, and I did not break a law. Now, we're going to get to the ethics. We're going to get to the ethics because is that the right thing to do? No, it's not the right thing to do. So I was using that as just a funny way to start. But technically, I did not break the law because it's public domain. So now let's get into current copyright law. Where do we stand now in the US? Okay, first of all, It's regulated federally, right? It's in the Constitution as under the authority of Congress. This is not a state decision. That's why we don't have different copyright laws across different states, and it's not local governments. That also means that a police officer, right, a county police officer, city police officer, even a state FBI agent, right, for your state federal bureau of, or state bureau of investigation, cannot enforce anything about copyright. It can only be regulated and enforced at the federal level. So any copyright cases would go to federal courts to begin with. Any copyright infringements would have to be enforced by the FBI or other federal enforcement agency. Okay, federal. The length of current copyright. So if you write something and it's yours, right? It's new. It's not Amazing Grace. Is the life of you, however long you live, plus if you opt for a 70-year extension, right? And that applies for works created on or after October of 1998, which is when that new law was passed. So things before 1998, I think, would have been a possible 50-year extension if they opted for it. And then before that, it was even less than that. I think it was the 28 and 28, maybe, can't remember. But as we progress now into the mid 20th century, where things that are created, let's say in the 1970s, 1980s, 1990s, when those things become public domain is going to get increasingly more difficult to figure out, because it's just not as clean cut, because they keep changing, how long it's initially copyrighted for, and then how long the optional extension would be. But anything that's after 1998, life of the author plus 70 years if you take the extension. So actually 1929 for public domain. Anything that's created on or before 1929. I did the math this morning. I got that number wrong on this slide, but you get the point. Anything that's before then, public domain. Now let's get into the religious service exemption. This is also in the law, in the statutes. And I put the statutes here on the slide, and I think I also included them on the handout, if that's helpful for you, if you really want to get nerd out on this stuff. The performance of a non-dramatic literary or musical work, or of a dramatico-musical work of a religious nature, or display of a work in the course of services at a place of worship or other religious assembly. All right. So performance is a very important word. Okay. And the display of a work is very important, right? So within a religious assembly or worship service, what this means is this exemption, it does not include reproduction. That word is not used, reproduction, right? So if you're taking a copyrighted hymn and you're copying it 100 times, that's reproduction. Okay. And so that's not covered under the religious exemption clause. But let's say, let's take something that most people know that's still copyrighted. Let's go with, I don't know, How Great Thou Art. No, that is still, did that just go? Well, let's choose something better. Someone put something in the chat that's copyrighted that most people would know, and I'll use that as the example. How about that? Can someone chat me? Throw something up there that's copyrighted that we can use as an example. This will also help me see if you're actually paying attention. Okay, How Great Thou Art was put in the chat. That's one. Okay, I'm pretty sure that's still under copyright. How Great Thou Art. All right. If you just sing that, wrote, right? It's not on a screen. You haven't copied it anywhere. You're just singing it because people know thank you, 1953. Everyone knows the refrain. right? And you have the verses memorized. If you just sing it in a worship service, you do not have to pay for a license. You don't have to do anything other than just say, we're going to sing How Great Thou Art, and you sing it. That is covered under the religious exemption clause because it's a performance of a musical work in a religious assembly or a place of worship, or in the course of services at a place of worship, right? So you don't have to pull a license. Now, if you copy the hymn 100 times and hand it out, that's reproduction. So then you do need a license, right? You have to pay for that. That's not covered under the religious exemption clause. Now, the thing that's nebulous here is it says that the display of a work in the course of services at a place of worship or other religious assembly is under the religious exemption clause. Now, the current understanding, mostly being pushed by people that own these copyrights or hold these copyrights or administer these copyrights, is that if you project a hymn up on the screen, that counts as reproducing, right? Because you had to type it in, and that's reproducing it. And that's why there are licenses to cover that. That has not been litigated. So until it is, we'll either just have to follow the rules handed to us by the copyright administrators or take your chances. Okay. And we'll talk about that later. It also does not cover, as far as we're being told, it does not cover recordings of that service. So once the service is recorded and then it's put up on YouTube or Facebook or whatever, when people watch it again, that's also currently, we're being told by the people that administer copyrights and do these license stuff, that is a reproduction of the work, not a performance of the work. See what I'm saying? Also has not been litigated. If you have questions, put them in the chat, or there's also the Q&A feature, which we'll use at the end if it's a question for the end. Jim just said, if you want 100 hymnals with How Great Thou Art, but reproduce it for use in worship on screen or bulletin, does that make a difference? If you own the 100 hymnals, then you should, then if you're going by a very strict interpretation of the law, you need to use those 100 hymnals to sing it. If you reproduce it 100 times, that's 100 new reproductions of that hymn. So technically, someone could claim in court that breaks the law. That's not covered. Now, ethically, and Lisa just said, what does display refer to? Well, display, as I understand it, it says here, let's see if I can highlight it. Can I highlight this? Yeah. Eraser, no. Color. Yellow. Oh, man. That was terrible. Well, you get it. Display of a work in the course of religion, that would be like holding up a piece of art, right? So the artwork is copyrighted, but you can display it, right? Or if you had a hymnal, you could hold the hymnal up and display it, but you're not reproducing it. That's the meaning of display. As far as I understand it, that's what it was supposed to mean. Okay. Let's move on. And if you have more questions as we go, just put them in there and I'll circle back to them at the end. Wait, why is this still here? Let's see if I can get rid of this eraser. There we go. Better. All right. So now one of the big questions as we get to the current copyright situation and all this stuff is there's a lot of anxiety. I've experienced there's so much anxiety out there about this. So I want to address it. Can my church get raided for copyright infringement? There are these stories. I don't know if some of you have probably heard them, like, oh yeah, in the 80s, these churches got raided and their choral music libraries. And all right, so technically, yes. If the federal government thinks that your church has infringed on copyright, they could come check that out, right? But realistically, no, right? There's no way that an individual church that's copied a few things illegally is going to get raided by the FBI. It's not worth the money or the time or the effort, right? Because the amount of damages would be minimal, right? And so it's just not worth the time or money. However, that story does have some basis in reality, that in the 80s there actually was one of the very few church music copyright litigations that happened, and that was FEL Publications sued the Catholic Bishop of Chicago in the Seventh Circuit Court in 1985. So if we back up, in the 70s, FEL Publications put in the initial lawsuit, and the district court looked over the evidence and during discovery, and gave the Catholic bishop an order to collect all the publisher's materials in the parishes and deliver them to FEL. So this is discovery. And so the Catholic bishop ordered all of the parishes in the Catholic diocese to round up any of FEL publication stuff in the libraries, whether it had been, if it had been copied or whatever, and given back. And the evidence showed that unauthorized copying of their hymnals and song sheets and various things, everything that FEL had published at the time, had occurred in 238 parishes during the 3-year period that they were addressing. So after this was, love this chat going on the side. Yes. The jury awarded $190,400 for the copyright infringement, as well as a $1 million punitive award and a $2 million compensatory damages as well. So 3.1, almost $3.2 million total. Okay, so this is one of the reasons why technically, yes, you can get rated, but realistically, until you reach the hundreds of thousands of dollars, it's not worth going to federal court over, because you have to pay for lawyers and you have years of expenses and time and effort to litigate these things and actually get your damages back. So realistically, no, you're not going to get rated, especially if you're basically trying to do the right thing the whole time. But it has happened. Now, an appeals court, the Catholic diocese went to the appeals court, and they actually vacated the $1 million punitive and the $2 million compensatory damages that were awarded. So ultimately, the Fells Publishing Company only got the $190,000 award. All right. So, yes, that did happen. But if you're in a denominational structure where each congregation is a self-owned entity, right? You're not a part of a diocese that's actually one kind of entity as far as the government is concerned. It would be very hard for a publisher to make the case that you had damaged an artist $100,000. Right? They would never go to court over that. And they can't lump you all together because you're not the same entity. So they'd have to sue all of you individually. Be craziness. Whoa. All right, that was a long chat from Mark. Mark, I'm going to circle back to that. And if it's not addressed, I'll address it at the end. All right. So now that we've kind of gone over what the law says, and one of the very few litigated cases as it pertains to church music in particular, let's talk about the ethics a bit. Because as people that work for the church, I think doing what's right should be important to us. So first of all, the idea of copyright is a culturally bound idea, right? It is something that is cultural. There are cultures around the world who do not subscribe to the idea that art that is created is owned by an individual. There's this really wonderful document from the World Council of Churches that was published in 2005, and one of the fellows of the Hymn Society from Brazil was instrumental in helping this come to being. Samaya Monteiro, and it's called "Love to Share: Intellectual Property Rights, Copyright, in Christian Churches," and it's a really well written, thoughtful document on and kind of a call to action to try to come to an agreement on how we should deal with intellectual property rights worldwide. So it's a great document if you want to read it. For the US in particular, the spirit of the law is, as the Constitution states, to, quote, promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. So it's to promote progress. Another way to say this would be to promote progress by preventing long-term monopolies by publishing companies, right? We don't want things to be held so tightly for so long that we can't then create new derivative works and feel free to really take the next steps in various artistic endeavors. So it creates a public domain so that works can be used in ways that promote progress without fear of persecution or fines. But it also is trying to encourage creators to continue creating by creating these limited monopolies. But limited is the word that keeps being used in both the Constitution and subsequent laws that are passed to specify what that means. So was the right thing. Okay. In our current culture, and we're talking about the United States, right? Because we talked about this being culturally bound. So if you're from a different place around the world, different culture, you may have a different understanding of what the right thing is. But in our current system, in our current culture, artists should be paid fairly for their work when it is used. I think that's a fair statement to make. I think most of us would agree with it. Now, the question is, how much should they get paid? And for how long should they get paid for their work? Now, that's debatable. If you ask legislators in the 1700s, they'd probably say they should be able to do that for 14 years and another 14 if they really want to. But now, if you ask people, they may say, I deserve to have that right my entire life. Plus, I want to secure that for my family legacy. And so it's my life plus 70 years. Don't know. I don't know what the right answer is. The ethics of using songs from other cultures is complexified by the history of colonialism and racism. So it's not the right thing to take or use a song from a different culture and to just immediately assume that our cultural values and expectations should supersede the cultural expectations and values from which the song comes. That's not okay. But it's complicated. So I encourage you to read Marcel Storynagel wrote this wonderful article in the Hymn, which is still behind a paywall because I think, it's to 2021. Yeah, it's probably still behind a paywall, but it's about to not be. If you really want to read it and you don't have access to the summer issue of the Hymn in 2021, email me or the office, and we'll send it to you because I want you to read it. It's called A Tangled Web: Intellectual Property and Christian Global Song. It's a wonderful, just kind of synthesizing of the current situation of intellectual property and all these songs that are coming into North American hymnal collections and being used in various ways across these borders, which have different values and laws. And Marcel is just a wonderful person to learn from when it comes to that. So read that document. It's wonderful. All right, my general advice on what's right, the right thing to do. All right. Unless there's an obvious reason why the law is unethical, we should comply with the law of the land. So do your best to comply with current copyright law. Do your best. When questions arise about what is the right thing to do concerning copyright, keep the artist and or the song's culture of origin as the priority. Are you acknowledging them? Are you doing your best to honor them by the way you accessed it, learned it, and are currently using it? And finally, don't sweat the small stuff, right? The FBI is not going to show up on your doorstep because, you know, it was the Sunday of, and your 80-year-old alto lost her choral anthem and you didn't have an extra copy and you copied one so that she could participate that morning. I'm sorry. Like, don't sweat it, man. If you bought the thing and you need it so that that person can participate, and it's kind of a situation like that, let the 80-year-old alto participate, for goodness sake. There are bigger fish to fry in our ministry context than worrying about whether we correctly credited to him when we used it that one time in that service in 2019, right? Do your best. But if you're like, oh man, I messed up, just do better next time, you know? So let's talk a little bit then about the mechanics of copyright. What do we do when the rubber hits the road? What do we do? Brian, I'm here to learn what I'm supposed to be doing. I don't care about ethics or the history of the law. I just want to know what to do. Fine. You've made it this far, I will tell you. To do, if it's in public domain, which if it was created in 1929 or before, you are guaranteed that it is in public domain. You can do anything you want with it. You don't even have to say who wrote it. You can even say that you wrote it. Ethically, bad idea. But technically, you can do anything you want, right? You can arrange it. You can change it. Whatever. It doesn't matter. Just use it, right? Once again, try to honor the people that made it, but you don't have to pull any licenses for it. You don't need permission from anybody. You can just do it. Number 2, to sing out of a hymnal you've purchased, or to sing anything by rote, which means there's no printed music or no lyrics displayed on the screen or anything like that, you need no licenses or permission. Okay? Don't need to pull any licenses for that. The license comes with the hymnal that you purchased, right? You purchased for that reproduction by purchasing the hymnal. So if you're singing out of it, you're good. The artists were compensated. To print physically or digitally, right? To reproduce, to print the thing, record, or otherwise distribute copyrighted words or music requires explicit permission or a license. Okay, whether or not it's being used in a worship service. That does not fall under the religious exemption clause. So if you are going to put words up on the screen, if you are going to print it in your bulletin, the music or the words, whichever one's copyrighted, if both, whatever. If you're going to, anything like that, if it's copyrighted and you're reproducing it, then you have to have either direct permission from the copyright holder, or a license from someone who does those types of licenses, which I'll give you in just a minute. Okay. So in order to get permission or license, the first thing is trying to contact the individuals for every copyrighted thing you're using is just impractical. And so the easiest and cheapest way to do it is, and this is why these companies exist, is to use a licensing agent. The 3 biggest ones, and really you shouldn't need more than this unless you're doing some crazy stuff, is CCLI, right? CCLI incorporates every major Congregational Song publishing company except for GIA. So If you're using things by Hope Publishing, if you're using anything on the CCLI Top 100 or in that kind of contemporary genres, CCLI will cover it, right? So you can go to their website, just Google it, or I think I linked to it in the handout. Buy a license. They have a great Q&A section or like FAQ page. You can use their license. CCS, the Christian Copyright Solutions, it's probably the third largest. It's the smallest of these three, but they do offer a lot of publishers. It's not as comprehensive, I think, as CCLI or One License, but it's significant. So you could check that one out. And then One License. One License, once again, has every major Congregational Song publisher, artists, and stuff available, except for Capital CMG, which is the major holder and administrator for copyrights of things you would hear on CCLI Top 100. Your Hill songs and Elevation and things like that. So if you're not using any of that type of literature, then One License is probably your best bet. So there you go. Now, reporting. Once you have the license, typically reporting is required. Each different license holder will do that differently. So make sure to read their FAQ. OneLicense.net, I believe, has a quarterly system where once a quarter, they expect you to fill in everything that you've used that needs to be reported. It's just easier to do it every week. If you can, it's really quick. But if you can't, maybe once a month would be a good practice. CCLI has a different version of that. I think they're still doing a sampling system where you only have to report if they're actually pulling a sample from you, and so they'll contact you. But there's different, but that's changing. So you just pay attention to your license and make sure that you stay on their mailing list. So that's pretty much it. Now I'm gonna I lost track of the chat. So I'm gonna try to catch up on the chat here, and I'll just read it as it comes. And then if you have any other questions, put them in the Q&A, and I will do my best to answer all of your questions. Okay, Mark. I'm a hymn writer, lyricist who writes lyrics and sets them to existing hymn tunes, and they're in public domain. Hymns are being sung pretty widely at churches across the US, and one hymn has recently been sung at a church in Wales. I've been told by a music minister friend that I can consider my hymns to be copyrighted simply by fixing my name and the year when the lyrics were written. I trusted that advice. Not sure of this. Yes, they are correct. It's not like a patent where you have to submit. You don't have to submit like an application or something to some governmental office. They're correct as long as you can prove in court that you were the first one to create this thing, and you have kind of a record, which could simply be an email or some sort of saved file on your computer that's like, this is the piece of these are the lyrics, and this is my name, and I claimed it on this date. It'll stand up in court. That's the only time you would need to prove it, is if it went to court. So I wouldn't worry too much about it. Publishers have ways of kind of archiving these types of things that I'm not 100% sure of, but yes, it is copyrighted as soon as you make it. It's yours. You just need to be able to prove that in court. You don't have to register it anywhere. Okay. Now that actually then begs the question of how do you enforce it? So that's the problem with self-publishing. If you're self-publishing, you're responsible for browsing YouTube and watching out for people copying your music without your permission. And then you have to be the one to say, hey, you're doing this illegally. I need to be paid for that, or you need to take it down. Practically speaking, it's very difficult for most people to do themselves, right? Because it's very time consuming. And you have no way to really enforce it unless if someone's like, it just ignores you or says no, you'd have to take them to court. Are you going to do that? Probably not. It's expensive. So that's one of the reasons why, publishers exist, right? Because then your copyright is administered by the publisher. And they're the ones that can say like, hey, YouTube, these people are using this work illegally, please take it down. And they kind of take care of that type of policing. But even for them, it's difficult because there's a lot of stuff. Let's see. It's your intellectual work and therefore your intellectual property cannot be used illegally without appropriate permission. Yes, that is correct, Linda. Thank you. Creative Commons. Oh, great. Yeah. Linda, thanks for mentioning Creative Commons. You may have heard of Creative Commons, folks. That comes up in the World Council of Churches document I mentioned called Love to Share. Creative Commons is a way to copyright your artistic endeavors with varying levels of control. So the base Creative Commons understanding is anyone can use this as long as they say, I'm the composer or artist or whatever, right? But you can use it in any way you want. But then there's different levels where you could also specify anyone can use my hymn except for if they want to make money off of it. If they want to monetize my work, they need my express permission, and they would have to pull some sort of a license or get permission from me and pay me money. But other than that, you can freely use it without any fees or other express permission. So there's like levels where you can add qualifications to your Creative Commons. I would encourage a lot of hymn writers to do that. It's much more clear. It gives people permission to use it, which I think you want them to do. And then at the same time, you can also say like, this is Creative Commons, but if you want to pay me for this work, $5 for the use by your congregation would be fair, or whatever price point you set. Thank you for mentioning that, Linda. Yeah, you can check out Creative Commons. They have their own, you just Google it and there's a lot of information on a website about it. Woody Guthrie's copyright notice, Judith Conrad's. So this song is copyrighted in U.S. under a seal of copyright number for a period of 28 years, and anybody caught singing it without our permission will be mighty good friends of ourn, because we don't give a darn. Publish it, write it, sing it, swing it, yodel it. We wrote it. That's all we wanted to do. That's funny. Thanks, Judith. Let's see. Linda follows up saying, I recommend you include a copyright symbol and lyrics written copyright date. Exactly. Yeah. So Linda's right. Once you write something, if you just put the copyright symbol, your name, and a date, that'll hold up in court. So and it's just clear as well, right? For reference for other people, and they're interested in when things were written and things like that. Do we need to watch for composer or lyricist family estates or publishers that have renewed, extended the copyright even pre-1929? Not pre-1929, because even if they renewed it before 1929, there's no way it would still be copyrighted, because there was no way to renew it this far into the future. So for sure, anything 1929 or before, public domain, hands down, no questions asked. Now there are works, hymns, and other artistic things, but we'll say hymns for now because that's what we're talking about. There are hymns written after 1929 that are public domain, right? Because if they didn't ask for the extension, if they didn't apply for the extension, if they said, when I die, that hymn is going into public domain, that's their choice. They made that decision. There are those situations as well. So once again, after 1929, it gets more tricky to determine if something is or is not public domain. This may, let's see. Oh, I jumped to the bottom here. I gotta get back up. What do you do? Okay, there we go. Da, da, da. This may be beyond the scope of this presentation. Do the same or similar obligations restrictions apply in Canada? We have the CCLI and CCS service available here or elsewhere. Yeah, I'm sorry. I don't know Canadian law, and I didn't research it for this presentation. I would imagine one thing to look up would be, are they members of, did they sign on to the Berne Convention? BERNE, I believe is how it's spelled, but it should be in the handout that I provided. If they've signed on to the Berne Convention, then yeah, you're dealing with very similar situations, especially as far as like how long things are copyrighted for. So once again, 1929 or before, it's going to be public domain in Canada as well, things like that. But but beyond that, I can't be terribly helpful, and I apologize for that. You found that one license is more comprehensive than CCLI for composers of organ, piano, and choral works. Yeah, I'm focusing on congregational song for this presentation, so I'm not particularly knowledgeable, or wouldn't want to say on a recorded presentation more about that, Lisa, on the difference between one license and CCLI for non-congregational song things. Does music used for prelude, postlude, offertory, etc., need to be covered by copyright? As long as you're not reproducing it, like as long as you're not like if you bought your score and you're playing it, no, that's it. You bought the music, and so it is implied that that is permission to use it because you didn't reprint that music and you're just playing it. It'd be the same as like rote singing, right? It's the same with choral music. It's why if you buy the choir music for your choir and you sing it in a religious service, as long as you're not displaying the lyrics on the screen or things like that, you have not reproduced it in any way. You're just simply performing it, and that does fall under the religious exemption clause, right? So prelude, postlude, offertory stuff, as long as you're not printing the music for everybody and God to see, then you're fine. Okay, Lisa, and Lisa said, I was speaking about streaming worship services, not necessarily just performing it in the service. That's a very good question. It is not clear. You'll get different answers from different people. I think that a recorded worship service that's being viewed again by somebody in the future is still a worship service because they're viewing it, and by viewing it, they have entered into the worshipful space. I think this is a very 21st century conversation. This whole idea of digital worship and worship beyond time, right? Or through time, because now we have the ability to worship people in the past, right? Because we can actually be quote unquote with them in the digital realm because they've been recorded. I think that would hold up in court, but I have no idea if it would. It's never been litigated. And so whether that is reproducing the work, don't know. Now, if you're showing the lyrics, that is reproducing it, right? Because you've reproduced the actual lyrics. But if it's just simply talking about singing or performing a copyrighted work and then it's archived as a worship service, then I think that's covered under the exemption. Where I run into, Catherine says, where I run into difficulties is trying to locate composers who are not covered by GIA, CCLI, or others. Google search sometimes works. How about if you can show that you have given a good try, give it the old college try. I've run into that situation many times. And if you're going strictly by the law, if it is copyrighted and you don't have permission, then no, you're not supposed to do it. However, I think if you've given it the old college try, and it's something that is designed for Christian worship, like it's a hymn or something, and you just simply can't track them down, and it's not obviously covered under any of your licenses, I think you should use it. And then if someone circles back to you and they say, hey, you use my thing without permission, then you can say, I'm so sorry. It was so meaningful to us. I did my best to find you. I couldn't do it. And I'm so glad you found me. How can we compensate you? The other way to handle that is sometimes one license, CCLI, and others make it more difficult to find the obscure works. So if you already hold a license with one of those or both of those entities, you can do a manual submission. So you can manually, there's usually a little place that's like manual submission or submit something that I can't find or whatever. You give them as much information as you have on the piece, and then they will then tell you, we don't have this, or we do have this, it's covered, we put it in for you. That has happened to me sometimes as well. So you can look for that. So morally and legally, two different answers from Brian. Once again, not official legal advice. I am not a lawyer. How do you ask for an extension? That's a good question, Celine. I'm not sure. I'll have to look that up. No one's ever asked me that one. I bet one of our publishing friends knows the answer to this. I bet they do. In fact, I bet Scott Shorney knows the answer to this, because they had a hymn that was about to go out of copyright, and they deal with this type of stuff. They have a lot of older hymns where that's going to be a thing, where they're renewing and things like that. So I will check that out. But sorry, I can't answer you now. As a composer, Robin says, as a composer, I've had to learn that if I'm not the first person setting a text, you know what? I'm gonna unshare my screen, because you don't need to necessarily be staring at questions. Where did it go? Oh, it went back to the bottom. Okay, I've had if I'm not the first person setting a text, the copyright might no longer be held by the author. The author is fine with me setting it. Fortunately, while lyrics copyright was assigned to the publisher of the earlier setting, my setting can be distributed and performed using one license. Yeah, right. So sometimes when your things are published, you actually sign over the copyright to, right? Then the publisher actually owns the copyright. So then you can't get permission from the composer, because they don't own the copyright on it anymore. And that was their choice, right? They're getting paid for it. Sometimes it's a really good choice. But whoever owns the copyright, and the copyrights can be passed on to estates, to other entities like publishers. So you really have to get permission from the current copyright owner when you're doing like a derivative work or something like that. I had a bride recently who wanted all the music from Twilight for wedding music. There was no published arrangement of most of them. I told her I couldn't play them because of copyright issues. Truth was, I didn't want to play them. I could have fudged my way through after listening a few times. Was I honest enough? You lied. Um, maybe next time be more honest with them that you don't think it's appropriate. Or that you don't feel comfortable playing that genre of music because you don't feel like you're good enough at that genre, right? Which would be the same thing I would say if someone wanted me to play some, 19th century or like 19th century French Romantic music on the organ. Yeah, I'd be like, you don't want me to do that. So I think maybe just be more honest next time. There wouldn't have been a copyright issue as long as you're not reproducing reproducing the music or text in any way. Oh yeah, the handout. I bet if I just click paste. Yep. So I haven't copied or pasted anything. I just pasted the link to the handout again. You're welcome to download that. There you go, Martha. Copyright does not last forever. In Canada, copyright generally lasts the life of the author plus 70 years. Right. So that would be like Berne Convention with a little extra thrown on there, just like the US did. Streaming. Okay, Linda says streaming, recording, and sharing or otherwise sharing online is duplicating. Yeah, I don't think that would hold up in court. It depends on what you're talking about, which part of the service you're talking about duplicating. But if everything's being done by rote, I would make the case that it's not, it's still part of the religious service. And so it would be covered under the exemption. But if you're reproducing lyrics or things like that, like you're showing them, then yes, that is indeed true. Alf, love your name, dude. If I take a publish hymn in a hymnal and transcribe music into the appropriate key for a B flat instrument or an E flat instrument or an entire instrumental ensemble, am I breaking copyright laws? Man, yeah, I think so, but that's just dumb. Like it shouldn't be breaking the law. And I mean, because what are your choices then? Either you don't use it, and so then the hymn isn't as good as it should be, or you could contact the composer if they're living and you know them and you can get a hold of them and say, hey, can you transcribe? It's just they're not going to do that if they haven't already provided you with that resource, or if it's not for sale. Sometimes it is for sale, then you should just buy it. But if you have to do it in order for your instrumentalist to play it, and you've already bought the original, I think it's fine ethically, right? And once again, the FBI is not going to come banging on your door because you transcribed a trumpet part for one hymn. It's not going to happen. Facebook and other entities may mute segments they think are copyrighted and not credited. Yeah. There's nothing we can do to fix that system right now. It's mostly run by AI things that are trying to catch copyrighted materials, and it gets it wrong all the time. When we do the Hymn Society conference, I have to go in constantly and tell YouTube that this 18th century hymn is not indeed copyrighted by this music label or Sony or whatever, that it's actually was written in 1780, and we were just singing it, so get off our back. But I have to tell them that because the AI machine blocks it. It's ridiculous. All right. Oh, hey, I'm at the end of the chat, so there is one thing in the Q&A. It's the transcription thing. So I did it, and it's 2:01. That's pretty good. Are there any other questions or thoughts? Anything that I missed? Boisterous applause for the most compelling copyright presentation you've ever seen in your life. Thank you. Thank you. You didn't think it would be this entertaining, did you? I did my best to make it fun because it's not exactly a fun topic, but I hope it was helpful. And if you have any other questions, there are people that know more than me about this. Some of them work for entities like One License or at one of the publishing companies. But the Hymn Society is a good resource to reach out to us. If we don't know the answer for sure, we can find someone who can help you better than us. So feel free to reach out anytime. And by golly, sign up for the conference in Detroit because it's going to be a good one. So go to thehymnsociety.org/event, and you'll see all about our summer conference, which is going to be a wonderful event hosted at Wayne State and the Cathedral of St. Paul in Detroit. So hope to see you there. Thank you all very much, and look for next year's webinar series that we're working on right now, and we'll probably announce sometime this summer. Take care.